So hi everyone, and welcome to this very topical event that we're organizing today, together with the Center for Fundamental Rights at the Hertie School of Governance in Berlin, and with the Refugee Studies Center here in Oxford. We are very much indebted and very grateful indeed to Janina, Victor, Ruby, that is joining us online today. Hi, Ruby. Can you hear us? Can you hear us? Great.
Absolutely, yeah.
Brilliant. And of course to Catherine for accepting to chair and moderate this session. My name is Christos Kypreos. I'm the research manager of the Bonavero, and on behalf of our director, Kate O'Regan, and all of the Bonavero, indeed, we would like to welcome you all today. And without further ado, I'm going to pass the floor now to Catherine to speak about the event.
Thanks very much, Christos. Many thanks to all of you who are joining us today in person and online. As was mentioned, this is a joint event hosted by the Bonavero Institute here in Oxford, the Refugee Studies Center, and the Center for Fundamental Rights at the Hertie School in Berlin. For those of you who don't know me, my name is Catherine Costello. I'm now a professor at University College Dublin, but I was formerly based in two of the co-organizing events, the Refugee Studies Center and the Hertie School in Berlin. Today is Tuesday, the 27th of February, 2024, 1 month after the International Court of Justice ordered provisional measures in the case brought by South Africa against Israel concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip. As you are no doubt aware, the case arose out of the armed conflict in Gaza, which began in response to the appalling attacks of the 7th of October 2023 on Israel, in which some 1,200 people were massacred. Highlighting the context, the president of the court, Judge Donoghue, stated that the court was acutely aware of the extent of the human tragedy in the region and deeply concerned about the continuing loss of life and human suffering. The court also emphasized that all parties to the conflict in Gaza were bound by international humanitarian law, calling for the immediate and unconditional release of the hostages taken by Hamas and other armed groups. Of course, those armed groups were not before the court, one of the many asymmetries in the particular legal context. Since then, the death toll has increased, as has the destruction of civilian infrastructure. The death toll now stands at over 30,000 people in Gaza. We acknowledge that some of you listening and indeed contributing to the event may be deeply personally affected by these terrible events, but we hope that this event, in some very small way, can nonetheless contribute to developing some greater, perhaps shared understandings of the legal issues. As you know, the court did not order a ceasefire, but rather we have 6 provisional measures aiming to prevent genocide and its incitement, to take immediate and effective measures to enable urgent humanitarian assistance and basic services, and to prevent the destruction and ensure the preservation of evidence. Israel was obliged to report to the court within 1 month about measures taken to give effect to the order. The deadline for that report was yesterday. As I understand, the report is not public, but South Africa will have an opportunity to respond. The court, in these provisional measures, of course, did not make any substantive findings, but rather its orders are premised on plausibility. But as Nico Krish has written, in the context of genocide, even a finding of a plausible claim is shocking and extraordinary. No state should even get close to the point at which an allegation of genocide becomes plausible. Judge Nolte, the German judge, in his separate declaration, noted, however, that the Genocide Convention is not designed to regulate armed conflict, and also regretted how much the parties to the case talked past each other during the oral proceedings. In this event, we aim for an open discussion on the wider legal issues and those that remained under-examined in the orders. Professor, now also Judge Hilary Charlesworth, has long reminded us that international law as a discipline of crisis tends to ignore larger structural questions. However, also currently before the ICJ is the advisory opinion sought by the UN General Assembly on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. Extraordinary oral submissions have been heard in the past days. 52 states, including evidently the State of Palestine, and 2 international organizations have made submissions. Notably, 35 of those states and international organizations that have addressed the legality of Israel's occupation of Palestine have argued that it was unlawful. Only 2 of those who addressed the occupation argue that it was lawful in their written submissions. That's the US and Fiji. And I understand that Fiji has now changed its legal position. At this critical juncture, we have brought together a panel of outstanding speakers, bringing very diverse expertise and perspectives. Their full biographies are on the event website, so I will just give them the briefest of introductions. Janina Dill is Dame Louise Richardson Chair in Global Security at the Blavatnik School of Government at the University of Oxford, a Professorial Fellow of Trinity College, Oxford, and co-director of the Oxford Institute for Ethics, Law and Armed Conflict. She's a leading scholar on the role of law and morality in war, developing both legal and philosophical theories, grounded, I should say, also in very detailed empirical study about how international law can be an instrument of morality in war, albeit an imperfect one. Ruby Ziegler is Associate Professor in International Refugee Law at the School of Law in the University of Reading. We're very sorry he couldn't join us in person today, but he had in-person commitments both sides of this seminar, so I know he wasn't able to join in person for very good reasons. He's also a research associate at the Refugee Studies Center, and he's a widely recognized expert on international refugee law, in particular its interactions with international humanitarian law, a crucial question in the context of Gaza and more widely, and also on questions of citizenship, denationalization, and political participation. Thirdly, and absolutely not last but not least, Victor Catton is Assistant Professor in Public International Law at the University of Nottingham School of Law. His extraordinary body of scholarship, recently cited in argumentation before the International Court of Justice, addresses Palestine and international law, often in comparative and historical perspective, with important contributions on the crime of apartheid, partition, and self-determination. With that, I'm going to hand over to our first speaker, Professor Janina Dill. The format is that each of our speakers is going to speak for about 10 minutes, and then we'll have a couple of questions from me. At that point, we'll pause the recording of the event, and we'll have some questions from the online audience, and then we can have a more intimate Q&A in the room as well. So with that, I'll hand over to Janina. Thank you.
Thank you so much for having me. Thank you, Catherine. For decades, Israel's conduct in the occupied territories has raised legal questions, both about the persistence of the occupation, but also about the periodic military operations that Israel conducted, particularly in Gaza. Both the legality of the occupation and how Israel is conducting operations in Gaza are now simultaneously subject to deliberations before the International Court of Justice. Some states have called these deliberations misplaced, meritless, even morally repugnant. Experts have called them lawfare and worse. So let me therefore start by clarifying that it is a legitimate expectation that the Palestinian people have, but also the people of Israel, that international law, that a court provides a forum for the critical evaluation of Israel's conduct. It should be an aspiration of the entire international community, including the United Kingdom and Germany, that politically charged questions with high moral stakes like these are evaluated by a court. This is how the rule of law works, and this is how the international legal order should work. Of course, there are political and moral risks associated with both cases. I will now focus exclusively on the contentious ICJ case over genocide, in which the court argued a month ago, and I quote, "There is a real and imminent risk that irreparable prejudice will be caused to the rights of the Palestinians in Gaza." What rights? I quote again, "The rights to be protected from acts of genocide and related prohibited acts in Article 3 of the Genocide Convention." So the military operations that risk violating the Genocide Conventions have in fact caused unfathomable human suffering, including over 12,000 dead children. That's about as many as this university has undergraduate students. These operations responded to a heinous terrorist attack, and Hamas continues to violate international law, for instance, by not releasing the hostages. This fact, however, leaves Israel's obligations under international humanitarian law unaffected. Experts have accused Israel, in the context of these operations, of violating prohibitions on the arbitrary denial of humanitarian access, on the use of starvation as a method of war, on the willful attack against vehicles and personnel involved in humanitarian assistance missions, on rendering useless objects indispensable for the civilian population, on attacks that either willfully or disproportionately damage a range of protected objects, including hospitals, schools, places of worship, on the destruction of enemy property without imperative military necessity, on attacks against persons not participating directly in hostilities, on outrages upon personal dignity against persons in the hands of the enemies. I'll stop here. The crisis of compliance of international humanitarian law is a phenomenon that academics have long thought of as associated with non-state armed groups in protracted civil wars that unfold far from the gaze and attention of the international community. It is important for us to state that Israel upholds and continues to uphold that its operations comply with IHL. I think it is equally important for us that we point out that the pattern of attacks, the scale of the destruction, the political and military explanations that accompany these practices, and several meticulous investigations of experts and non-governmental organizations of individual attacks together suggest otherwise. A definitive legal analysis specifically establishing criminality can only ever happen in a court of law. But law has other functions besides punishing individuals for criminality. First, law must restrain action. And second, it is meant to help us evaluate action and express where appropriate moral opprobrium. We cannot suspend these action guiding and evaluative functions of law until its punitive function has had time to unfold, since that naturally must take several years. So those who repeat the obviously correct point that we cannot definitively prove war crimes from afar must take care not to thereby undermine IHL's ability to restrain conduct and guide our moral judgments. We can and must say when conduct looks like a violation of IHL, for the sake of the people it is meant to protect, but also for the sake of the authority of international humanitarian law. Everybody knows that fully legal war is still a moral catastrophe, but it is not this. So in short, we should welcome the ICJ, as well as the many other governmental and non-governmental organizations that are currently partaking in the effort to bring law to bear on this context. Let me now turn to the risks associated with this effort. I see two reasons for why the ICJ genocide case may not in fact strengthen the two functions of law that I just mentioned, so to help us evaluate conduct and to restrain conduct of the parties to the war. The first is that the court does not have jurisdiction overall, arguably the most important or relevant legal question. And I believe that this risks weakening the law's evaluative function. And the second is that the court has little to no control over how states react to its pronouncement, which risk weakening the law's action guiding or restraining function. Let's talk first about jurisdiction. And we know that the court has jurisdiction over disputes arising under the Genocide Convention. But I trust that all here present understand that genocide is a very unusual crime and that it is very, very hard to establish, particularly as the wrongful act of a state, rather than as the criminal conduct of an individual. Everything hinges on the special intent to destroy in whole or in part a protected group. Unless the court has direct evidence of this intent, for instance, in statements, and can then show that this intent has been invested in acts in Gaza that violate the convention, it is left to infer this intent indirectly from conduct. And the court's prior case law has set an almost impossibly high bar for inferring this intent indirectly, by arguing that genocidal intent must be the only intent plausibly inferable from an action. I quote here from the Bosnia-Serbia case, for a pattern of conduct to be accepted as evidence of its existence, the existence of this intent, it would have to be such that it could only point to the existence of such intent. This is not only a very high evidentiary bar, it also overlooks a common feature of human intentionality, which is that people often have more than one intent when they act. There are two dominant doctrinal approaches to understanding intent in law. One focuses on the consequences of action, so just what is foreseen is intended. And the other one looks at what is desired or welcomed as a consequence. So the intention is what is implicated in the purpose of your action. Now, international law on the use of force regulates foreseen consequences, even those that are 100% foreseen, with the principle of proportionality. It separately regulates intention with the principle of distinction, suggesting that what is intended for the purposes of international law in war is more than what is foreseen. It is what is welcomed, desired, what is implicated in the purpose of an action. Now think of your own actions. We often have more than one consequence that we welcome or desire as part of our actions. We have more often multiple purposes in action when acting. By definition, if this is the case under the approach of the ICJ, intent becomes no longer legally inferable because it is never the only plausible intent that can be inferred from an action. So one plausible outcome is then that the court will find on the merits that genocidal intent cannot be shown. This could be because Israel is not in fact violating the Genocide Convention in Gaza. Out of respect for the court in the legal proceedings, I would not prejudge or speculate whether this is the case. But it could also be because of this very high bar for showing intent, which is an unusual doctrinal approach. The risk for both cases is that the judgment that there is no genocide will be interpreted as implying that a legal evaluation has shown Israel's conduct in Gaza not to be wanting. This would be a wrong interpretation in either case, but we have already seen a significant amount of spin just on the provisional measures. So if we recall that one important function of international law is that it is meant to guide how we evaluate the use of force, then a judgment about a very specific and partial question, potentially against the background of a very specific doctrinal approach, if not understood and contextualized properly, can weaken rather than strengthen the evaluative function of law. That is one risk. The second risk lies in how states react to the court's pronouncements. The provisional measures have not been without effect, and it's important to point this out. But states have also partly failed to react in line with arguably what are their legal obligations. Now, Israel stands accused of not complying with the order to let in more humanitarian aid, and in fact dealing with incitement of high-ranking politicians. But I would like to focus here on third states and their continued transfers of weapons to Israel. States' most straightforward legal reason not to transfer arms to Israel at this particular moment does not, in my view, emanate from Article 1 of the Genocide Convention, or even from general international law, which prohibits aiding and assisting in internationally wrongful acts. Both of these prohibitions, and we might be able to talk about this later, have their own intent and knowledge requirements that again give room to argue that they do not apply an outright ban on weapons transfers to Israel right now, though this is contestable. However, Common Article 1 of the Geneva Convention states that parties undertake to respect and to ensure respect for the present convention in all circumstances. It does, in my view, imply such an obligation not to transfer weapons to Israel at this moment. It arguably did so before the ICJ's provisional measures ruling, but the ruling still matters. Let me explain. The commentary to this provision in the Geneva Convention states that states must do everything reasonably in their power to bring any violation of IHL to an end. This does not imply that the assisting state intends the violation of IHL to which its arms transfer contribute. This violation needs to only be foreseeable. It hinges on what James Crawford argues as the awareness of the facts. Arguably, that awareness that there is a serious risk that arms transfers contribute to violations of IHL should have existed prior to the provisional measures order. But I think the due diligence requirements, which the commentary to the Geneva Conventions recognizes here, have been raised by the ICJ not throwing out the case at the provisional measures stage. Of course, you may say the ICJ said nothing about IHL other than reminding both parties that they must comply with it. Of course, it is also true that violations of IHL do not often, most often, implicate genocide. I can even imagine the reverse, a genocidal act of killing, for instance, that does not violate also a concrete provision of the Geneva Conventions and the protocols. This is entirely possible, hard as it may be to imagine. However, I submit to you that we know, looking at history, that when a state commits genocide, even when there is merely a rising risk of the commission of genocide, forced displacement, starvation, outrages upon personal dignity, and the large-scale destruction of civilian infrastructure are the non-contingent manifestations of this risk. So the court not throwing out the allegation of genocide as implausible at the very first opportunity should have raised states, should have put them on notice to inquire more closely whether these non-contingent facts are present in this context, and whether their continued transfers of arms do not violate their common Article 3 obligations. Now, the United States, Germany, and the United Kingdom have not reacted in this way, and this risks undercutting the authority of the court and of the international legal order more generally. Because, as several UN experts calling for just such a ban on weapons transfers just yesterday reminded us, international law does not enforce itself. Thank you.
Can everybody hear me? Yeah. I think we'll call on Ruby next. Ruby, you're an expert on IHL and questions of displacement. And this was one of the issues which Judge Nolte noted that the parties to the conflict were in. This is one of the issues that Judge Nolte, in his separate opinion, noted that the parties in the conflict were sailing past each other and not addressing arguments. So I wonder if that was something that you could address, and also perhaps some of the wider questions about displacement, non-refoulement, the right to flee, in particular given the very acute situation in Gaza that this is. Thanks, Ruby.
Thanks very much. Can everyone hear me well? I hope so. Is that good? Well, thank you, and I'm really sorry I can't be there in person. It just happened to be the case that I'm bookended with multiple events here at Reading, and you can see the lake just behind me. And as Catherine said, it kind of falls on me to deal with, I think, three related but distinct questions. One is the question of evacuations within the Gaza Strip and potential forced displacement outside the Gaza Strip, the question of the right to flee and non-refoulement obligations, and the question of Article 1D of the Refugee Convention in the context of UNRWA's operations in Gaza and the potential effects of defunding UNRWA on those operations. And to do all of that in 10 minutes, and also, I think has been mentioned earlier, to do so through an intersection of three distinct international law areas: international humanitarian law, international human rights law, and international refugee law, which all apply in different ways in the context of what's happening in Gaza. So let me start with that first question, and that distinction between evacuations and forced displacement. I think the first distinction to be drawn is, of course, between evacuations where a side is ordering the evacuation of its own population, as Israel has done both in the south of Israel and in the north of Israel, and as has happened in other conflicts as well. This may raise questions of human rights law within a jurisdiction, but it doesn't engage, as you were, IHL, and in fact, we would expect sides to do that in order to protect their own population from harm, at least subject to certain proportionality requirement. Not so easy when the order relates to a different population, to the adversary population. And since 2005, there have been various debates as to the status of Gaza, as to whether Gaza is or remains an occupied territory. But what is clear is that since October 7th, Palestinians in Gaza meet the definition of protected persons within the meaning of Article 4 of the Fourth Geneva Convention, which is people who at any given moment and at any manner whatsoever find themselves, in the case of conflict or occupation, in the hands of a party to the conflict or an occupying power of which they're not nationals. This very clearly applies to Palestinians in Gaza. And so the norms that pertain to those circumstances from both the Geneva Conventions and indeed the additional protocols, particularly additional protocol 1 to the convention, are relevant here. And here, I think the first distinction to be drawn is between evacuations internally within Gaza and evacuations or potential forced displacement for outside Gaza. So we're all familiar with that effective order that was given in the first weeks after October 7th for people in north of Gaza to move to the south of Gaza. And from a point of view of international humanitarian law, the question here is rather complex, because the general norm, the general prohibition in Article 49.1 of the Geneva Convention is, of course, a prohibition on forcible transfers or deportation of protected persons. However, Article 49.2 does say that the occupying power may undertake total or partial evacuation of a given area if the security of the population or imperative military reasons so demand. And arguably, or there could be an argument that if you want to minimize harm to civilians, then Article 57(2)(c) of the additional protocol, the one that talks about precautions in attack and effective warning to civilians, supposedly does potentially require certain evacuation. But the problem is this. Firstly, one needs to be sure that the motivation indeed is military reasons or the security of the population involved. And the problem is that we have had various statements from Israeli government ministers where the aims of the war as a whole, and potentially of evacuations more specifically, are more challenging, right? Where they talk very explicitly about the wish for Palestinians to no longer be in the Gaza Strip. And so that mars those considerations. The second problem is that Article 49(3) then of the Geneva Convention talks about the requirement of contracting states like Israel to ensure then that proper accommodation is provided and that removals are effected in satisfactory conditions of hygiene, health, safety, and nutrition. And we know that the ICJ has pointed precisely to those issues, particularly in Provisional Measure 4. Right? So the question of internal evacuations is complicated enough. When we talk about forced evacuation or deportation from the Gaza Strip, the standard in international law is much more severe. In other words, for Israel to be evacuating or forcing people outside the Gaza Strip would only be possible under Article 49(2) if, for material reasons, it is impossible to avoid such displacement. And I think that is a standard that's going to be very, very difficult to meet. So I think it's pretty clear that there will be a difficulty, legally at least, for Israel to order any sort of evacuation or displacement from the Gaza Strip to outside the Gaza Strip. And the UN Security Council draft resolution, I note, actually calls very explicitly on Israel not to do so. But what's interesting is that the same draft Security Council resolution says nothing about the corollary question. I move to the second point, which is what happens if individual Palestinians want to leave the Gaza Strip? So rather than being pushed outside the Gaza Strip, they want to seek safety elsewhere. And the elsewhere, the most obvious immediate elsewhere, is Egypt. And I think it is important to note here that in international refugee law, in international human rights law, the idea that non-admission and rejection at the border qualify as a violation of a norm of non-refoulement when non-refoulement applies is very clear. It's been reiterated fairly recently by the European Court of Human Rights in the ND and NT versus Spain case. And we've seen in many other conflicts globally, we can point to Turkey opening borders to displaced Syrians, and indeed Lebanon, to Chad now opening its borders to displaced Sudanese, Pakistan and Iran, at least to some extent, and now there's a bit of a pushback, opening its doors to Afghanis, Bangladesh to Rohingya refugees, and indeed Poland and other EU countries to Ukrainians. So the question arises, what happens with Egypt, right? So, and I think here we need to first apply the relevant international law frameworks. So the first is international human rights law. So if we accept, as the ICJ indicated in its provisional measures, that the conditions in Gaza are such that there is a risk to life or freedom of Palestinians in large parts of Gaza, then those non-derogable rights that people have under the ICCPR, Article 6, the right to life, Article 7, freedom from torture or cruel or human or degrading treatment or punishment, and indeed Article 3 of the Convention Against Torture, they would apply, and those entail a right to non-refoulement. And Egypt, of course, is a signatory to those conventions. It is also a signatory, as indeed all countries are, to the Geneva Conventions. And Janina has already mentioned Common Article 1. I've written separately, and the ICRC has accepted my position, that the obligation to respect and ensure respect for the conventions in all circumstances includes non-refoulement obligations to situations where the person being refouled will face a risk to violations of their rights under the Geneva Convention. And as we've established, that risk, at the very least, is very real, if not already materialized. And then thirdly, there is international refugee law. There's Article 33 of the Convention. So that takes me, and that's the basic norm of non-refoulement. So that takes me to Egypt's concerns. So Egypt talks about having concerns around security, obviously, the inability potentially to distinguish between civilians and combatants. And it is true that the Refugee Convention in Article 33 actually distinguishes those situations and allows state parties on an individual basis to deny non-refoulement obligations, as you were, to people who pose an individualized threat. But of course, we cannot paint with a broad brush the entire Palestinian population of Gaza in that way, and it would be wrong for Egypt to do so. And similarly, the concern around the time and ability to return is one that, from a political perspective, from a realpolitik perspective perhaps, we should absolutely acknowledge, given the history of the 1948 war and displacement from what has become Israel after that war. But the question whether that should be a basis to deny individuals their right to leave a territory where they face a risk, I think is one that we must pose. And I note anecdotally that aerial footage suggests that Egypt is actually now building a world buffer zone 2 miles wide on the Gaza border that's been uncovered by CNN last week. So I want to turn to the last point that which is on UNRWA and Article 1D, and that very much relates to our earlier discussion. So the Refugee Convention often is called, or often is conceived of, as having excluded Palestinians from its application. But that is a misconception of the convention. What the convention has said in Article 1D is that as long as Palestinians in the areas where UNRWA operates, that is Jordan, Lebanon, Syria, the West Bank, and Gaza, enjoy UNRWA's protection or assistance, then they do not need to enjoy protection or assistance from other countries. But when that protection or assistance ceases for any reason, which is the language of Article 1D2, if it ceases for any reason, then those individuals are ipso facto, by that fact, becoming convention refugees. And the only exception to that is it if they fall under one of the exclusion clauses in the Refugee Convention. For instance, if they had committed war crimes or crimes against humanity, then they would be excluded. Now, why does that matter? It matters because if Palestinians were to be able to leave the Gaza Strip in one way or another, then arguably the defunding of UNRWA, which we have seen from 17 states and the European Union, exacerbates an already critical position that UNRWA already found itself in provision of services. We now know UNRWA has stopped providing services in the north of the Gaza Strip. And that suggests to me, and indeed suggested to the Advocate General of the European Union, Emilio, in an opinion she published in January, before the defunding application or has been applied, that suggests to me that any Palestinian who would now leave the Gaza Strip and who had previously relied on UNRWA's protection or assistance, that is 87% of the population of Gaza, would be ipso facto subject to exclusion on an individual basis, eligible for refugee protection in any contracting state of the Refugee Convention. And that to me is something that I'm not persuaded all countries that have taken this defunding decision, and I leave aside the morality and the extent, which perhaps we'll get to in question, of whether that itself is not compatible with the ICJ provisional orders and affects them detrimentally, that they have not considered the implication that that would have for Palestine refugees anywhere globally. I think I'm just about out of time, so I'm going to stop it there. And I hope that was sufficiently expansive, but also troubling.
Thank you so much, Ruby, for covering that range of legal sources so admirably. As you said, the picture is bleak, and I think this question about the right to flee and the international human right to leave any country, including one's own, is really so stark in the Gaza context, given the years of blockade. Victor, we're going to turn to you now. I was just wondering if you could share some insights into the wider legal questions that have a bearing on the situation in Gaza, but more widely. And also perhaps give us some insights in your experience into Palestine's legal strategy before international court, including the way that the argumentation about the breaches of, or alleged breaches of the prohibition of apartheid are becoming increasingly, I guess, mainstream and respected. Thanks, Susan.
Thank you very much, Catherine, for that introduction. I'd also like to thank Kate Reagan, although she cannot be with us today. And it was a pleasure to listen to Janina's presentation and Ruvy's. So I'm going to focus in my 10 minutes today on an issue that's arisen in both the case that South Africa brought against Israel under the Genocide Convention, as well as in the advisory opinion proceedings, the written and oral statements which just ended yesterday. And I think it's striking in this regard, if we talk about first case under the Genocide Convention, that of 153 states parties to that convention, it was South Africa that brought the case against Israel. I mean, think about that. Not a single member of the League of Arab States instituted the proceedings. Not a single member of the Organization of Islamic Cooperation instituted these proceedings. Not even the State of Palestine instituted these proceedings. And I'll remind you, the State of Palestine is party to the Genocide Convention and has direct access to the ICJ under Security Council Resolution 9, which was acknowledged by the International Court of Justice in the case Palestine instituted against the United States of America under the Convention on Diplomatic, the Vienna Convention on Diplomatic Relations. That remains pending. So why South Africa? Why did the country that suffered from apartheid more egregiously than any other nation bring this case? And why did 20 states of the 51 and 3 international organizations make forthright apartheid claims before the International Court of Justice in their written and oral submissions, including the state of Namibia, which devoted its entire submission to apartheid alone? So in my remaining time, I'm going to do my best to answer some of these questions and to explain why I think these arguments are significant and why an opinion from the court on this matter could be consequential. But before I do this, I think it would be helpful for me to briefly explain how apartheid is defined as a prohibited act and as a crime in international law. For apartheid is not just a pejorative, it's not just a slur, it's not just a word which we can throw out against any state whose policies we don't like. It's a crime against humanity. So apartheid is broadly prohibited. It's prohibited under international human rights law in very widely ratified treaties, including the International Convention on the Elimination of All Forms of Racial Discrimination, Article 3, to which Israel and South Africa are parties. It's also prohibited under international humanitarian law. It's defined as a grave breach in Additional Protocol 1, very widely ratified treaty. But I want to focus on the definition of apartheid as a crime against humanity, which is what's been raised before the International Court of Justice. And I should also add the International Criminal Court. There are 2 conventions which define apartheid as a crime against humanity. The first is the Suppression Convention, 1973 International Convention on Suppression and Punishment of the Crime of Apartheid, which has 109 states parties, not including South Africa and not including Israel, but it's been argued that it reflects, definition in Article 2 reflects customary international law. And the way in which apartheid is defined in Article 2 is it's a mix of international criminal law violations and international human rights violations. It's more broadly drafted than the Rome Statute. And although that convention was drafted primarily thinking of apartheid in Southern Africa, it was interpreted by states parties in their reports to the Group of Three as applying more broadly than that, and including, even in the 1970s and 80s, the State of Israel. The Rome Statute of the International Criminal Court defines apartheid as a crime against humanity in Article 7, and of course that statute was adopted after the end of apartheid in South Africa, so it obviously applies beyond South Africa. The definitions between the two overlap, but the international criminal, the Rome Statute's definition is purely international criminal law. The way in which it defines is it focuses on the structure or regime of government in which multiple crimes against humanity occur. Focuses on domination, systematic oppression, and institutionalized regime. Now, what's important about the Apartheid Convention, in contrast to the Genocide Convention, which Professor Janina Dill mentioned in her conversation, is that unlike genocide, it's much easier to prove intent under the crime of apartheid. You have to prove intent or a purpose to maintain an apartheid regime. And this can be demonstrated by referring to a state's laws, regulations, administrative acts, its constitution. In the case of Israel, the nation state law, for example, from 2018. And there's also an overlap between the definitions of apartheid and genocide. And that might explain why apartheid is referenced in South Africa's application instituting proceedings against Israel under the Genocide Convention. So the Group of Three, for example, in their 1985 report explained that the crime of apartheid is a form of the crime of genocide. And if you look at the definition of apartheid in the 1973 convention, that's Articles 2, A, B, and C, they correspond to the same clauses in the Genocide Convention. For example, the deliberate imposition of living conditions calculated to cause a protected group's physical destruction, in whole or in part, is mentioned in both definitions. Let me say something about Palestinian strategy. So I would argue that the success in having so many countries refer to apartheid in their written statements, the advisory opinion proceedings, is due to Palestinian strategy, although it was one that was primarily led by civil society, going back to the years following the 2004 advisory opinion on the wall, which was seen as too narrow, focusing solely on the wall and its associated regime. We had a report by South African Professor Joan Donoghue when he was a human rights special rapporteur in 2007, who raised the possibility of going back to the court for an advisory opinion that would look at the question of apartheid. This resulted in a 2-year study by the Human Sciences Research Council of South Africa. Donoghue was on that, was involved in that study, as was I, Max du Plessis, John Reynolds, and others. I noticed that Donoghue and du Plessis are also advising South Africa in the genocide case. Subsequently, UN mandate holders, Falk, Link, Albanese, also made the same points, referred to apartheid in a second advisory opinion. There was then a report published in 2017 by the UN Economic and Social Commission on West Asia by Richard Falk and Virginia Tilley, which had to be suppressed and removed from the website of the UN agency after it was condemned. And yet the following year, after the adoption of Israel's nation state law in 2018, apartheid was then back on the agenda. In close succession, reports by B'Tselem, Human Rights Watch, and Amnesty were produced. Then Russia invaded in Ukraine and imposed sanctions. The United Nations Permanent Fact-Finding Committee, chaired by a South African, Navi Pillay, said the occupation had assumed a permanent character, referred to statements by Israeli leaders. And then following that, the question was referred to the International Court of Justice. Now, something else happened in this period. There was a very important meeting that took place in Dublin, in which the question was considered for the court. Originally, the question made no reference to discriminatory legislation and measures. It was purely focused on illegal occupation. But during that meeting, there was a bit of a debate. A dissenting note was circulated by one of the members who made the argument that it would be remiss not to include a reference to discrimination, given that it was now the issue that was being debated by all these blue chip human rights groups. And so a reference to discriminatory legislation and measures was added to the draft. Question voted through the Decolonization Committee and in the UN General Assembly. And it seems to have been very successful. As I said, more than 20 states and 3 international organizations have made much reference to apartheid in their statements. Now, I realize my time is short, so I'm just going to conclude by explaining why I think it's significant. In fact, I think it's significant regardless, even if the International Court of Justice does not deliver an advisory opinion. I think it will. That addresses apartheid. Even if it does not do that, the fact that 16 of the 20 states that made this argument are state parties to the 1973 Apartheid Convention is significant in and of itself. This is because there is a treaty monitoring body. So that treaty, despite being a relic, you might say, of the Cold War and having its treaty monitoring body suspended in 1995, could be re-established. The treaty has never been denounced. And during the last meeting of that committee in 1995, the chairwoman explained that she had suspended the meeting for the time being and that it was taken without prejudice to any subsequent reactivation of the monitoring mechanism of the convention. And she also explained that when the convention was drafted, it, and I quote, applied to any country that might practice racial segregation under an institutionalized regime. Accordingly, any one of these 16 countries could call on the Human Rights Council, which has replaced the old Human Rights Committee, to take steps to reconvene the group of 3 under that convention. And I'll save the remainder of my talk to the discussion about